Yes.
Namdi Manna.
No, this I had received this someone this morning informed me that he's indisposed. It's sent one letter, but I just took out a printout.
Accused number 4 is in discussion. The other accused
Register. What's the name of this accused for?
William Carey.
Huh?
William Carey.
Yes, give me the petition. Other accused persons are
The
present.
accused are present.
All.
All of them are present.
All right. I record all the accused persons are present. Just give the name of the accused persons. How many are there?
1, 2, 3, 4, 5, 7.
Six.
Six as of now, 6.
All six are here before this court. All right.
6.
Present along with defense counsel Sri
M. Lindo.
M. Lindo. Learned Defense Counsel has filed a petition number 21/26 dated 19/3/2026 under section. Is it 205 for BNS?
No, that's 205 for the old.
Look at the petition. No, look at the petition. Do you have a copy of petition with you?
No, I didn't bring on.
But it's an application under section 205 for BNSS. If I'm not mistaken, it's 355, I believe.
205 is
the old one, John. 205.
No, but old one, then it has to be CRPC.
Yes. Hello, we'll make that.
Please correct it. Put your initial there. File an application. What will be the appropriate section?
So you're on the 355.
File an application under section 355. Inter-alia, praying for dispensing the personal appearance of the accused William Carey Manar on the ground, on a medical ground. The application is supported with a medical certificate issued by the doctor. Then a prosecutor Shri so-and-so present and has placed before this court letter dated 19 March 2025 26 addressed to this court by the IO stating that the IO is indisposed today on health ground. As such, he could not appear before this court for his evidence. Refix for evidence. Prosecution is at liberty to take rest step. Personal appearance of the accused William Carey Manar is dispensed with only for the day. Is dispensed with for the day. It's for evidence. Please keep it record. Yes.
Your Honor,
Yes.
the accused person can take
Yes.
Order, the crimes hand.
Witness present.
Who is the witness?
Person who is informed police.
He's present before his court
Yes,
today?
yes.
Where is he? Yes, next.
That's all.
So doctor is present. Yes.
Yes.
So the evidence can be taken. Cross, we can do it on the next day.
No.
This is a doctor who had examined the accused, sure that he was fit at that point of time.
Yes, you can cross. What's there?
Simple as
I don't have instructions, Your Honor.
No, no, no. You may not have instructions, but the court will not function as instructions.
So,
We are not subservient to your instructions.
yes, Your Honor.
When the witness is there, unless there is a compelling circumstances, then only we can adjourn. Now, what is there so difficult for you to cross-examine? You cross-examine. When do you start cross-examining? You cross-examine. You seek instruction from your senior. The doctor who is examined the accused has come.
to show that he was fit at that point.
Only for that purpose. Okay. It's not a very important witness,
Yes, yes.
but nevertheless, the doctor has come. We will not adjourn the matter. And no keeping the cross-examination reserved. Why should the doctor come again and again? Where is the doctor? You have come from which place?
Rocky.
Look, he's come from another corner of the state. So we will not ask him to come again. You please cross-examine. Okay. If you want us to take up this matter last, we'll take up last.
Yes, yes. Can do that.
You can take time to.
At the end of the board, Your Honor, I'll just.
Yes. Yes, next.
Starvin, Namin.
Witness present. The informant. PSF.
Is that onion bag and everything?
Yes, Your Honor.
Huh?
Yes.
Okay. Yes, Talbanus.
Starvin,
Your Honor, for Tagros, I like to beg your state for adjournment, Your Honor. For the-
But file a petition.
This will be fine.
Have you filed?
No, Your Honor, we haven't.
On what ground we seek adjourn?
Your Honor, actually on medical grounds of the conducting counsel, Your Honor.
All right. Learned counsel for you, but please file a petition
Yes, yes.
supported by affidavit. The
Yes.
petition should be supported by an affidavit. Learned counsel for the learned prosecutor series so and so present. Learned defense counsel series so and so present. Has filed a petition number so and so dated so and so. Inter-alia praying for adjournment of the instant case on the ground that the conducting counsel, then on the ground and submits that he's being led by senior counsel in the instant case. The senior counsel is indisposed today on the health ground. As such, prays for adjournment. All right. Prayer for adjournment is allowed. Refix for a final argument. Please file a petition.
Yes, Your Honor.
Accused, where are the accused persons? You record both the accused persons are present and prosecutor present. But can we not start? And because we have already heard this matter, we can hear the prosecution.
The conducting senior counsel wants to do it by himself.
No, all right.
Same day.
Okay. Okay.
Reminiscia,
Hmm.
Edaman, Mukim.
Now, please, who is there in this case? Please be here. We'll pass the judgment.
Right, sir.
Please, the counsel be here.
Yes, sir.
You assist me on the dates.
Right, sir.
Okay. We'll pass the judgment. Yes.
Bolang Kis crime.
Yes.
313, Your Honor.
Yes.
Put the accused person's name.
Helpful. Have you started? Have you started? All right, we'll not do today. Present. So. Present. Refix for further examination of the accused under 313. Yes, next. What is this case, madam?
302.
How many witnesses?
Only 5 witnesses, Your Honor.
Sorry?
5 witnesses, Your Honor. But Your Honor, if this person is not here, I could not inform him. When I call his phone number, always knowledgeable, Your Honor.
So what do you want?
Your Honor, kindly issue BWA against him, Your Honor.
This is a legal aid case.
State Defense Counsel, Your Honor.
Who is appealing? Learned additional prosecutor Sri S. Chansang present. State Defense Counsel M. Suchian present. The accused Sibas Silla is absent without any steps. Learned Defense Counsel submits that the accused that she has lost contact with the accused. Issue bailable warrant against the accused. Yes.
One of the
Yes.
accused persons can take leave.
Which
Or
case?
voluntary.
Yes, 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 yes,
Tribunals or
yes,
obligor.
yes. Yes.
MSC.
Hmm.
Pen krau bon lang ka.
Hmm. Yes. Yes. Who is appearing for whom?
I'm appearing for the opposite party, National Insurance Company.
All right.
I'm appearing for
Just a minute. Riwan P. O. Nongtudu. Who is representing Riwan P. O. Nongtudu?
That one has passed as party.
All right. ICIC Lombard.
I'm appearing for
Alright. Then ICIC Lombard General Insurance Company. Earlier it was known as Bharti AXA. All right. And National Insurance, who is appearing?
I'm appearing.
All right. What is this matter fixed for?
For filing a written statement from the opposite party number 3. And
You.
Yes, sir. Ready to file it?
You are ready?
Yes.
All right. What is this claim? Oh, don't open the file. Just tell me what is this case?
Injured.
Huh?
Injured.
Injury.
Yes.
Why two insurance companies are there?
This court has allowed.
You have filed a written statement, isn't it?
Yes.
So what is your stand?
Standard.
You are claiming compensation from whom?
From both.
Lombard.
Yes.
From Lombard or National Insurance?
Before I filed only ICICI self-claim, Your Honor. And then later the court allowed me to implicate another party of the offending vehicle. Your Honor.
But you are claiming compensation from whom?
Not all claim from the implicate party, Your Honor.
National
From the
Insurance.
national.
Lombard, you have nothing to do.
Yes, Your Honor. In this instance case, there are two vehicles involved, Your Honor. One is the Scooty and one is the Maruti, Your Honor.
So he was riding on the scooty.
He's the rider of Scooty, who has the insurance of ICC Lombard.
Then pay.
In this case, Your Honor, this honorable court void on the last occasion was instructed me to pay on personal own damage claim. Your
Yes,
Honor.
that's what
But
happened.
then, Your Honor, if you produce from the insurance, the own damage claim has already expired, Your Honor.
What expired?
The insurance policy, the policy.
When the accident took place.
Yes, Your Honor.
Well, policy was not valid.
The own damage, Your Honor. The policy already expired, Your Honor.
Policy expired means?
In this personal own damage, Your Honor.
Let us forget about that. When the accident took place?
On the 9/2/2023, Your Honor.
9/2/2023. The policy was valid from which date till which date? No, you are saying that the policy expired. Tell me the policy commenced from when and expired when?
No, Your Honor, in the personal.
Just answer me one question. The validity of the policy.
It's from the 19th of March 2021 to
19 March.
To 18 March 2000.
One second. 19 March.
To 18 March 2026.
19 March which year?
2021.
21 till?
To 18 March 2026.
18 March 2026. Yes. Boli? This is the validity of the policy.
Yes, Your Honor.
The policy was for a period of how many years?
The policy.
One second. The policy was for the period of how many years?
5 years.
5 years. Now tell me, what is it? Now tell me, what happened to the own damage claim?
Your Honor, I produce from this insurance only, Your Honor, that the period of own damage, it's from 19 March 2021 to 18 March 2022, Your Honor. The period for the own damage, Your Honor. In there is a column, Your Honor, period for own damage.
So for own damage, you have to keep on renewing.
Yes, Your
There is a
Honor.
policy within a policy.
Yes, that's the instruction which they have put.
Okay, but please, why do you talk like these instructions? Are you subservient to your company? You are a lawyer, you know law. Don't say like these instructions, instructions. You are supposed to lead your company will lead you.
I should lead the company.
Then you are a legal officer. They may not know the law. Now, please tell me one thing: is that in the policy, there is a policy within a policy. That means once you obtain an insurance covering the own damage, for the own damage you have to keep on renewing every year. No, that's something I fail to understand. Policy is the validity of the policy is from 19/3/2021 till 18/3/2006 for the period of 5 years. Now, during the validity of the policy, the own damage will expire.
I'll seek clarify instruction, Your Honor, so I will be able to pay on this own damage, Your Honor. We'll ready to. I'll propose clarification from the company, and I will instruct them to pay on the own damage claim, Your Honor, since they are
That's
claiming.
ridiculous. That's ridiculous. You file for this own damage in the consumer.
Okay.
You file for the own damage in the consumer.
Okay.
We will put you in extreme difficulty. This is unfair trade practice. Like I'm getting into a contract with you, and you secretly keep another condition also in the contract. That there is a contract within a contract. The main contract will be for 5 years, and there is subcontract very cleverly in a subtle way. You have put it there that your personal damage will be for 1 year, and he has to keep on renewing. And how much he has to pay for renewing for OD claim? That is very dangerous. How much he has to pay for OD claim every year?
Yeah, but it will give me that.
It can't be. Once you have taken a premium for 5 years, how much premium did he pay? No, you are not the owner of the vehicle. You paid the premium.
Yes, Honor.
You paid the premium. This is own damage case.
Yes, Honor.
You are the owner of the vehicle.
Yes, Honor.
You paid how much premium?
Vehicle Honor 1,289.
How much premium? What vehicle was it?
Scooty Honor.
How much premium you paid for 5 years?
3,285 Honor.
So he has paid the premium. The vehicle as well as the rider is insured, isn't it?
Yes, Honor.
So the vehicle and the rider both are insured. Now you say the vehicle is insured for 5 years and the person who's riding the bike is insured for 1 year. Did you pay extra money for insuring yourself?
No, Your Honor. Only the.
Did you pay any extra money for insuring yourself?
No, Your Honor.
Extra premium? Did you pay extra premium for insuring yourself?
Here only mentioned only for premium, only liability premium only.
No, like in insurance policy, na?
Yes, Your Honor.
You pay extra premium of maybe 100, 200 rupees to cover the workman, the handyman, the helper, and the driver. So extra premium has to be paid 100 rupees or 200 rupees, something like that. So is this the case that for the own damage also you have to pay extra premium? How much premium he paid?
Total overall 5,295. You know.
5,000.
6,249.
So then from where you are reading 3,000? Huh? You pay this own damage. Which year accident? What is the liability for own damage? How much? How much is the liability for own damage?
Only the company, or there's another branch who are looking for this own damage.
Oh, forget about the branch looking at that. Look at the policy. How much is the amount covered for the personal damage? There has to be a fixed amount.
15 lakh. You know.
From where? You read only the money. You don't read the contract, anything. 15 lakhs, yes, it catches your eyes. But other terms and conditions, it never. Where is it 15 lakhs? 15 lakh may be for debt. In case of death, 15 lakhs, isn't it?
Yes, Your Honor.
From where? Where? Please read.
Limited of liability clause under section 2 plus 1 subsection 1 of policy death or bodily injury, such amount as is necessary to meet requirement of the Motor Vehicle Act 1988 under section 2 1 clause 2 of policy damage third party policy is 1.0 lakh.
How much we are asking?
10 lakh, Your Honor.
And
Actually,
policy covers how much for your injury?
here the PA cover under section 3 of the owner driver is 15 lakh.
Do you have any evidence to show that you spent 10 lakhs for your expenses? On what basis you are asking 10 lakhs?
The injured is now is total half partial disabled, Your Honor.
You have certificate?
Yes, sir.
Then when the accident took place?
2000.
No, but what is this? What is this insurance company? Why are you doing like this? People get insured after paying premium, and then when they meet an accident, you start coming up with those technicalities which has no legal legs to stand. You can't have a contract within a contract, that too saying that the limited liability will be only for the purpose of 1 year and the policy will be for 5 years. This is deceiving people. How can you have such contract? It's not fair. But and you're saying that his personal damage is covered only for 1 year. From where you say so?
Policy itself, Your Honor.
Sure. Which page?
Annexure 8B on page 66.
Where?
Period of own damage, Your Honor.
Where?
And
The period of own damage. Period of compulsory PA cover. Read on top. 19 March to 18 March 2022. Period of own damage. Period of compulsory personal accident cover. From where you are reading that it is valid up to 21?
no, Your Honor, I'm saying up to 2022, Your Honor.
Huh?
I'm saying up to 2022.
When the accident took place?
On the 9, Your Honor.
9 when?
9/2/23, Your Honor. 9 February 2023.
And the validity of the policy for the vehicle is?
Up to 18 March 2026. Yeah.
You pay, otherwise we'll take it up in consumer. You file this in the consumer. We'll take it up and we'll pass order on this. And it has to be, you are corporate, you cannot do that. This is something which is unacceptable. This is a mischief. This is a mischief. This is
Okay,
mischief.
Your Honor, I'll tell them to pay on their own damage claim, Your Honor.
Either you pay, and you for them also to come to the quantum of the compensation. Come to the quantum of the compensation. They require some material, some evidence that you have suffered a loss of rupees 10 lakhs. Just saying that I want 10 lakh rupees. How can they pay 10 lakh rupees? How do you justify the 10 lakhs?
Your Honor, I'll call the that.
How do you justify the 10 lakhs?
We'll see all the medical expense incurred by the claimant, Your Honor. We'll
Please do
see, and
that.
then we'll scrutinize all the.
Still, we will keep this matter pending.
Yes.
Whatever personal damage you get, then after that, as a third party from him, we deduct and pay you also, if you're entitled more.
Yes, Your Honor, let it be in a long.
If you are
date.
entitled to more than 10 lakhs, then they can pay only up to the limited liability.
Yes.
Other than that, they will pay.
Let it be for a long date so that we can scrutinize all the medical expense and everything, Your Honor.
Yes, you please do it. But this is not acceptable.
Okay, Your Honor.
Please make one photocopy of this. This policy, make one photocopy of me, give it to me.
Yes.
Okay, one photocopy of this policy. Yes, learned counsel for the claimant, Shri P. Pide, present. Learned counsel for the OP OP Insurance, ICICI Lombard, Shri W. Dhar present. Learned Counsel for the OP National Insurance, Shri P. Pakma. H. Pakma present and has filed his written statement. You have filed a written statement?
Yes, Your Honor. File.
Fix this matter for issues and documents. During the pendency of the matter, Learned Counsel for the OP Insurance bracket ICICI Lombard shall examine the personal damage claim of the claimant and take decision. Yes. Yes. Yes.
Nariman's thing.
And you supply all the copies to him. Whatever the insurance requires. Yes. 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 Yes.
For the claimant, huh?
Yes.
From the opposite party, Your Honor.
Yes.
I have received the document, Your Honor, and two documents are yet to be submitted by the claimant, Your Honor. And in the
What
meantime, I have already sent a soft copy to the company, and they have started to process their claim, Your Honor.
Last time you said that you cannot process the claim for what?
Last time it was, Your Honor, we haven't received any intimation from the claimant regarding their OD claim. So as of now, they have submitted all the document, and I have sent it to the company, Your Honor.
Where is your company?
Guwahati, Your Honor.
Do you not have office here in Joy?
No, Your Honor.
Why not?
I don't know about that, Your Honor.
No, but what is wrong? We'll transfer this case. We'll take it up very seriously in the consumer. I mean, people are playing up with the people. This is we know that we are processing it. How long you have been processing it? How long?
Your Honor, on previous date and all previous date, Your Honor, they have told me that
While taking premium, you don't look at those anything, isn't it? While paying the compensation, you start all the nitty-gritties. How long you have been? How long you've been asking for time? See, how long you have been asking for time? In 18/11/2025, you made a submission before the court that the insurance company has paid a compensation for the damage for the vehicle to the tune of rupees 4 lakh. Parties are in the process of negotiating for the OD claim for the death of the driver. Now what happened? Now 2011, you and when there was no documents, then you should have then informed the claimant that you have not made any claim. But now after 5, 6 months, 7 months, you are giving them hope of settlement. Then thereafter you say that we have not received any documents. But how are you negotiating for settlement when there were no documents?
only previous date, Your Honor, for instruction I get is only that they are still processing. And after on the previous date, Your Honor, they told me that they haven't received the intimation. And after that,
we passed an order on 8/10/2025. Learned Counsel for the OP Insurance has seek instruction as to why the OD claim was not considered by the OP Insurance. We asked you to seek instruction that why did you not consider his OD claim in October 2025. Now we are March in 2026. That time they did not instruct you that they have not filed a claim.
they have already instructed me, Your Honor, but they instructed me
What is
only
the
for
instruction
the
came?
vehicle, Your Honor.
Huh?
Only for at the time only they instructed me only for the vehicle. Your Honor.
Become already paid.
Yes, sir.
Then you say that the OP Insurance has processed the OD claim of the claimant and it is at the final stage, 15/10/2025. These are all your submission before the court. Are you making a wrong submission before the court?
I'm making a wrong submission.
Then this is what on 15/10/2025 you say that the tribunal that the OP Insurance has processed the OD claim of the claimant and is at the final stage. Now from the final stage, again you are starting again asking for the claim from them. No, what is it all about? You can't play up with the court. Tell us what is the matter all about. Are you processing the claim, or the claim is at the final stage?
As of now, Your Honor, we are already processing that claim. Your
Should we call your manager here? I think so. You have to call your manager here. How much time do you want now to pay the OD claim?
After they submit all the document, Your Honor,
What all documents you want?
or KYC, they have to provide me
What is
KYC
it?
and for other document is
What
next of
document?
kin, Your Honor.
It stated that the legal heir has to be submitted. Certificate of legal heir. Your Honor.
What do you mean by legal heir
The
certificate?
applicant is the wife. Your Honor. We have provided even the marriage certificate also. Your Honor. And this is the intimation from the dealer. Your Honor. Have the intimation which are shared. Your Honor.
You ask your thing, otherwise I'll compel his appearance in the court. Ask your manager to come to the court. Last time you said that you did not receive the copy, isn't it?
Yes, Your Honor. For the intimation, they haven't received it.
Listen to me. Your submission was that you have not received the OD claim, isn't it?
Yes, Your Honor.
So we'll ask him to verify whether the OD claim was served to him or to the thing. The dealer has given, isn't it?
I have the copy.
Did you serve him?
Yes, he already.
And then?
I have already shared it with the company also.
And then why are they giving wrong instruction to you? You said that no such claim was made by the dealer. Now he produces a document to show that the claim was made. Every time you're making a wrong submission before the court. Why? Why are you making wrong submissions in the court? Either you take the responsibility of what you're submitting before the court, or pass on the responsibility on the person who's giving instruction for giving this wrong submission. You are taking the responsibility of this submission made by you before the court. Every time you're making a wrong submission in the court. What is this? Right from the beginning, you are misleading the court. Till last date, you said that you have not processed the OD claim because they have never made a claim. But he says that he disputes. He said that no, the dealer has sent the OD claim to you. And now they produce a document. Now they are producing a document. They have obtained a document from the dealer that OD claim was preferred before you. I tell you, manager will appear. Otherwise, I'll tell you, manager will appear in the court, and he has to answer all these instructions. Either you are making submissions on your own without any instructions.
No, it is as per instruction only, Your
Honor. Then we will call the person why he is giving wrong instructions. The manager will appear Monday. If he doesn't appear, we'll compel him to appear, or we'll charge him for making for interfering with the functioning of the court by making wrong. You file an affidavit that all these instructions, all these submissions made by you was on the instruction of your manager. Monday he'll appear. It's too much. Last date you said that you did not receive the OD claim, isn't it?
Yes, Your Honor.
But what is this?
This is the intimation, Your Honor. Your Honor,
what else do you want?
Your Honor, just give us time to process with the claim and we'll settle the matter, Your Honor.
No. We have given enough time. Monday he appears, or we will take coercive steps to secure his presence to clarify this. Matter will come up Monday. Monday will pass nasty order against you. If you look at the orders, what are the orders you're taking? You say that you are settling the OD claims, matter is at the final stage. Then suddenly you come and say that no, I don't know anything. We have instruction that he did not file any OD claim. He comes with a document showing that the dealer had filed a OD claim. How much premium did you pay? What vehicle was it?
16,000.
16. So, while taking premium, you take the premium. While paying, you have all the stories. This is that case, policy covers, you should have paid. How much is the liability?
15 lakh.
15 lakhs. Pay. Pay by month. Either you pay or you come. Monday will take up Monday. No, Tuesday. Learned counsel. Learned counsel for the claimant. Shri so and so present. Learned counsel for the OP insurance present. Show me that thing.
first page is the intimation, as well as the claim number. So it's there. MI claim number for the OD. This was processed from the dealer. And the rest are the documents which was sent by the dealer to the insurance.
Then, all right. Counsel for the OP insurance present. Present. As agreed. As agreed by the parties, the claimant has furnished the details of the personal damage claim made through the dealer, and the copy has been furnished to the counsel for the OP insurance. Then the counsel for the OP insurance has made submission from time to time that the OP insurance is considering settlement of the OD claim. The order sheet also reveals that the counsel for the OP insurance has made a submission that OD claim was at the final stage, which was recorded by this court. By the order dated 15/10/2025. Thereafter, the OP insurance has taken a stand that the OD claim was not preferred by the claimant. In response, the claimant has produced documents to manifest that OD claim was preferred. Making an incorrect submission in a judicial proceedings is a matter of serious concern. OP insurance has sought time on the ground that the matter is in the process of resolution. The counsel had made the submission on instructions are given by the OP insurance. This matter will come up again on Tuesday. The person who has given instruction to the counsel shall also appear before this court. The person/officer of the insurance company who had given instruction to the counsel shall appear before this court Tuesday. Who has given instruction to you this? That settlement?
Manager, Your Honor.
Tell he'll come. And if he doesn't come, then we are passing some nasty order. We will not allow such things in the court. Let it be clear, if they have not filed, they have not filed. They should know what's happening.
Your Honor, it was the last time they have clarified me, Your Honor, that at the previous stage they were waiting for a report for the TP claim. After that, after clarifying me, they told
One
me
copy
that
you give it to court. You have given?
I have a extra copy.
Give me this.
That can be kept.
As directed by this court. Show me the previous order. Last order. As per the order dated 13/3/2026 passed by this court, the counsel for the claimant has placed the copy of the OD claim made before the OP insurance before this court, which is taken on record. Yes. No, this is not fair. This is not fair. If you have to pay, na? Why are you doing like this? For since how many months?
6 to 7 months.
And he was resolving the matter, and what are you doing? You are part of that resolution. Did not inform you.
They inform me that in process.
In process. What process is that?
Not only others, previously they have clarified me that they were waiting for a report if there is any third party involved. So after that, they clarified me that after checking all the documents, they come across that they see that there is no intimation, another intimation for the death of the driver. So only the previous date I have submitted that we have not received that from you.
You have paid the compensation for the vehicle. Did you not know that the driver died?
So as of now, Your Honor, if you may allow us, we are ready to pay, Your Honor.
We are not in school that the teachers will threaten you to punish if you don't do your homework. They say, no, I'll do my homework. We'll punish you. This is court. It's not that. Why? If you wanted to do, who stopped you from doing it?
I'll talk with the company, Your Honor.
You talk, keep on talking. But if you wanted to pay the money, and that was OD claim is that is limited liability. He has to get something. It's a case of death. 15 lakhs is covered. You pay. What is the issue all about?
Your Honor, if you kindly give us one more chance, Your Honor.
We have given so many chances. No chance. Let him appear. But we are not very happy with the manner in which you have been, submitting before the court. This is not the way. It appears that you have been whoever is instructing you is taken the tribunal very lightly. He said, whatever we can speak and get away with it. No, this is not. We are recording whatever you are saying. Look, go through the order sheets. Look at your submission made before this court. Tuesday, tell him appear. If in the meantime, if you can settle the matter, settle. You come with 15 lakhs Tuesday. Come with a check of 15 lakhs, then that manager need not to appear. Okay.
Try to convey.
Whatever you want to convey. You don't want to convey. We'll see. Tuesday. Okay, Tuesday. A copy of this order shall be furnished to the. You take this order also. Okay. Copy of this order shall be furnished to the parties free of cost. Yes.
Laripar, Nini, Duarti.
Yes. What was the query put by court to you on the last occasion? We will not waste time. What was the query put by this court to you on the last occasion?
It's a distinction between.
Please answer that.
Yes.
What was the question put by the court to you?
A distinction between 197 CRPC and 119 PCRP.
Yes.
This is that section 197 applies to all public servants who act while acting.
From where are you reading?
I prepare notes.
Sorry?
I prepare notes, Your Honor.
Note. All right. Give me your note. Give me a note.
I have only one copy.
Okay, read.
Section 197, Your Honor. applies to all public servants for acts done while acting or pertaining to acts in the charge of official duty. While Section 19 applies only to corruption offenses under the Prevention of Corruption Acts. And under Section 197 CRPC create a jurisdiction bar and code. And Section 19 PC Acts create procedural safeguard, Your Honor. Section 197, a court cannot take corruption without a previous sanction. And Section 19 PC, a court generally cannot take corruption without sanction, object to a strict exception, Your Honor. Section 197, sanction is a condition precedent to cognizance, Your Honor. While Section 19, a sanction is required, but a defect are hearable.
You are relying on Swami's judgment, isn't it? Have you prepared your case?
Yes.
You are relying on Swami's judgment.
Yes,
Are you relying on Swami's judgment? Dr. Swami versus Dr. Manmohan Singh. Are you relying on that decision?
Yes, sir. No, this is not.
Are you relying on the decision of Dr. Swami, Dr. Subramaniam Swami versus Dr. Manmohan Singh?
No, Your Honor.
You're not relying on the decision.
Your Honor, this is new.
Sorry? What is that? What is that?
This is one citation we had already submitted as Sunita Tojeja versus State of UP, Your Honor. We had already.
Forget about that. Respond to my query. Are you relying on this Dr. Swami's judgment, Dr. Manmohan Singh, which talks about deemed sanction? Do you have the judgment? Do you have the judgment of Dr. Swami and Dr. Manmohan Singh?
Yes, yes.
Read para 38. The answer is there for a distinction between section 197 and section 19. Please read. You have not read, you have not come prepared.
The above passage is
Para 36.
yes. Authorised J has come to a finding that having regards to the nature of the office held by respondent number 1, it may not be expected of respondent number 1.
Come to the next page.
I also agree with the conclusion of brothers Singwi J, and that the appellant has the locus to file the complaint for the prosecution of the respondent number 2 in respect of the offences alleged to have been committed by him under the 1980 Acts. Therefore, I agree with the finding of Brother Singwi J that the argument of the learned attorney general to the contrary cannot be accepted. Apart from the learned attorney general, in the course of his submission, proceeded on his basis that the question of sanction has to be considered with reference to section 19 of the Prevention of Corruption Acts, hereinafter the PC Acts, or with reference to section 197 of the Code of Criminal Procedure 1973, hereinafter the codes and the scheme of both the section being similar. White para 3 of the supplementary written submission filed by the learned attorney general. In fact, the entire submissions of the learned attorney general is structured on the aforesaid assumption. I fail to appreciate the aforesaid argument and the same is contrary to the schemes to the scheme of section 19 of PC, and also section 197 of the codes In Sharan's Mahapatra versus State of Orissa, reported in 1998, 6 SC of 411, 1988 SC 295, 1998 SCW 2629. And this could compare Section 19 of the PC Act with Section 197 of the Code after considering several decisions on the point and also considering Section 6 of the old PC Acts 1947, which is almost identical with Section 19 of PC Acts 1958, and also noting law commission reports this code in paragraph 13 of Kali Sharan's paper came to the following conclusion.
Yes, read.
The sanction contemplates in section 197 of the code concerned a public servant who is accused by any offense alleged to have been committed by him while acting or purporting to act in the discharge of his official duty. Whereas the offenses contemplated in the PC Acts are those which cannot be treated as act either directly or even purportedly done in the discharge of his official duties. A parliament must have decided to maintain the distinction, and hence the following in the corresponding provisions in the former PC Act was materially imported in the new PC Act 1988 without any change in spite of the change made.
Stop. Have you read this part of the judgment? This is a judgment supplied by you, isn't it? This judgment is supplied by you to the court, isn't it? So have you gone through this part of the judgment where it talks about the distinction between section 197 and section 19? You have not come prepared. You are giving a judgment to the court only for what? So that we can thicken our file. You yourself, you have not read the judgment. Swami judgment, para 37 clearly makes a distinction. It carves out the distinction between section 197 under the CRPC and section 19, relying on the decision of the Supreme Court in 1987. You have not read. This is the query with us. The answer was there in the judgment relied by you only. You have not come prepared. This is one. Second, the other judgment you have relied on, that what is that state of UP?
Yes,
That what is name? Party's name?
Sunita Tutija was a state of UP and
Huh?
another.
Sorry?
Suniti Tutija was a state of UP and another.
Yes. Now this judgment says what? That Swami's judgment will not be applicable. Dim cross will not be there. Has he taken a contrary view to the Swami's judgment? What he says? What he says? What does this judgment says? Swami's judgment says that if for 3 months the government does not give, or the competent authority, if they don't run sanction for prosecution under section 19, then it shall be deemed. Sanction shall be deemed. But this Suniti, what is it? Totija. Yes, what does he say?
Para 31.
Yes.
National Legal Council for the Complainant had placed a reliance on the judgment of this court in several means Swami to lend credence to the agreement.
You're reading para?
Para 31, last page.
1 minute. No. Where are you reading? Why did you bring SEC citations? You're working with whom?
Second senior.
His chamber does not have SEC. He's a senior counsel. Why did you come with the SEC citation? Yes, which paragraph are you reading? We don't have these citations and all. We have only SEC with us. Which paragraph are you reading of this Protija? Which paragraph?
31 year.
1 minute. On the ground. What's that?
Last page.
Page number?
Page 11, last page.
Yes, please. Read, please.
Similarly, learned counsel for the complainant had placed reliance on the judgment of his court and subsequent Swami to lend credence to the argument of deemed sanction for prosecution. However, even if the judgment does not in any manner lay down the notion of deemed sanction. First, the said judgment deal primarily with the Prevention of Corruption Act 1988 and sanction for prosecution under the Acts.
Read, please start again.
Similarly, learned counsel for the complainant had placed reliance on the judgment of this court in subordinates Swami to lend credence to the judgment of deemed sanction for prosecution. However, even the said judgment does not in any manner lay down the nation of deemed sanction. First, the said judgment deal primarily with the Prevention of Corruption Act 1988 and the sanction for prosecution under the Acts. Secondly, GS Singwi J while opinion is spread, but a concurring opinion in the said judgment had given some guideline for the consideration of the parliament, one of which is to be to the effect that the end of the extended period of time limit, if no decision which is taken, a sanction will be deemed to have been granted for the purpose for prosecution. And the prosecuting agency or the private complainant will proceed to file the charge sheet or complaint in the court to commence a prosecution within 15 days of the expiry of the aforesaid mentioned time limit. However, such a proposition has not yet been statutorily incorporated by the parliament, and in such a scenario, this court cannot read such a mandate into the statute when it does not exist.
Yes, read the
Last para 32. Therefore, we are on the opinions that the learned magistrate was not right in taking cognizance of the offence against the appellant herein without there being a sanction for a prosecution granted by the competent authority. Afforded the High Court errors is not considering the facts that the sanction for prosecution was not granted by the competent authority under section 197 of the CRPC, and eventually the sanction was expressly denied by the competent authority. With respect to the allegation against the appellants, the necessary sanction not having been granted has awaited the very initiation of the criminal proceeding against the appellant herein. Consequently, the charge.
Yes. Yes, see, prosecution, this para 31.
Yes, sir.
What has happened with the sanction?
I've just received one copy, but it's not official. Yes.
Why did you take up with the director of prosecution? Is now your work is much more easy.
There is one communication, but not officially. I've just received it like that. It was issued on the 9 March 2026. I mean, a court of sanction for prosecution for former employees, MBA, MA, Meghalaya Basin Management Agency, an accused person, Larry Cooper Banks, Miss Naini Wanda, Aniti Pakma, and Dwarki Saman. Whereas it has been reported, actually, so for the accused person, the working with the Meghalaya Basin Management Agency Department, Government of Meghalaya during the period 22-23, while acting on or purporting to act in discharge of official duties, committed offences punishable under Section 120B, 409, and 420 of IPC, that was Section 7, bracket B, and 13 AB of the Prevention of Corruption Act. And whereas the matter was investigated by the Meghalaya Police, upon completion of the investigation, the relevant records, statement, and evidence were placed before a competent authority for consideration. And whereas the the undersigned, being the competent authority to remove the said employees from their service, has carefully examined the material placed on record and has applied due and independent mind to the facts, circumstances, and events of the case. Now, therefore, given before the facts, the undersigned hereby accords sanction of prosecution of Sri so and so, so and so, to enable the competent authority to take its cognizance of the matter and proceed in accordance with law.
But where is this sanction letter? They'll be forwarding.
They will be forwarding, but now I just received it. It's on the 9th it was issued. Application has been made, presented before the court, and now the sanction has been accorded. But officially, I have not received it. They'll be sending it.
What do you have to say?
I have one more judgment, rely on this.
Okay, tell what is the judgment. What
Your Honor,
what will we do with the judgment? Come to the facts of the case. What does the judgment say? The judgment says that they cannot produce the sanction now. Sanction order.
because Your Honor, since 17/10/2025, Your Honor, the time has been given to the prosecution to bring the sanction, Your Honor. Since now they are not provide the sanction, Your Honor.
So the law says what? What says that they cannot produce sanction order now? The judgment you are placing is that the sanction cannot be produced now. What does the judgment says you are placing? Let's see.
This judgment says, Your Honor, further the High Court erred in not considering the fact sanction was not granted under so and so section, and eventually sanction was expressly denied. In our case, it was not denied.
No, that judgment we read it, but then your judgment, that case involved sanction under section 197.
Yes, CRPC.
CRPC, not under section 19.
Section 19 in
Para 34, yes. They say that Justice Singhvi, while agreeing with in Swami's judgment, he was dealing with PC Act.
Yes.
Not under 197. You know what is the distinction between 197 and 19? The distinction between section 197 and 119. Section 197 of CRPC and section 19 of PC Act. Then I think the whole arguments, yes, what is their response now? They say that they will be producing the sanction order. One more judgment you have. For what? Show me. Yes. What is this? What does he say? Please read. State of Punjab, Pratap Singh. Yes. Yes. Yes, please read. Please read.
However, during the course of the trial, the complainant, Govinda Singh, deposed as Speedly won on and in his examination in chief, he said that it was the present respondent who had demanded the bribe, and it was on his behalf that the other accused, Vikas, had received the bribe amounts. The trial court defers the hearing on the request of the public prosecutor of the state, who then wanted to move an application under section 219 of the CRPC for summoning the respondent as an accused. Consequently, the application was moved by the state on 18/05/2017 under section 319 CRPC, which has allowed on 20th 05/2017 on, and Dr. Pratap Singh a worker was summoned to face the trial. If it comes to para 5, the accused respondent challenged this order of the trial court before the High Court, which has set aside the order of the trial court as sanctioned under Section 19 of the PC Act has not been taken. If it comes to para 7,
Yes.
there is no dispute on the facts that the respondent is a public servant as defined under Section 2C of the PC Act. Section 19 of the PC Act put a bar on court to take cognizance of an offence under Sections 7, 11, 13, and 15 without the previous sanction of the state government, or central government, or the competent authority. As the case may be, the relevant portions of Section 19 of the PC Act is as follows.
Yes. Then para 11.
It is a well-settled position of law that a court cannot take cognizance against any public servants for offences committed under Section 7, 11, 13, and 15 of the PC Acts, even on the applicants under Section 219 of the CRPC without first following the requirement of Section 19 of the PC Acts. Here, the correct procedure should have been for the prosecution to obtain sanction under Section 19 of the PC of CX from the appropriate government before formally moving an application before the court under Section 219 of CRPC. In fact, the trial court too should have insisted on the prior sanction, which it did not. In absence of the sanction, the entire procedure remains flawed. We are completely in agreement by the decision of the High Court and therefore are not inclined to interfere with the impugned order passed by the High Court, and accordingly this appeal is hereby dismissed.
Yes. How does it help your case?
This was the Section 219 has been someone additional accused person, Your Honor, because he was involved in that. And we agree that the order passed by the trial court, Your Honor.
Is this a case where any of your accused has been added as an accused who has not been arraigned as an accused in the charge sheet?
No.
The charge sheet has been filed against all the accused. We are not adding an accused here now. And this is what would happen during the course of trial.
No.
An accused who is a public servant, he was added as an accused. The question which cropped up for consideration was when a public servant who is added as an accused during trial and prosecuted for an offence under the PC Act, whether sanction under Section 19 is necessary. Then the Supreme Court said yes. A person cannot be prosecuted without sanction under Section 19, even if he's added as an accused during the course of trial under Section 19. There is no quarrel with the proposition of law that sanction is required. I don't think the prosecution is disputing that sanction is not required to prosecute a person. They say they agree. There is nobody's case that sanction is not required. You have relied on that decision. Yes. Para 35, para 31 says that that was just a guideline. The argument of the prosecution that they have applied for the sanction and the sanction has not been accorded as per Swami's judgment, it should be deemed to be sanctioned. But now you realize this judgment that the Supreme Court says that no, deemed sanction could be considered. So all right, fine, all fine. We could have discharged you because we don't relying on this decision, para 31. I will say that no, there is no such deemed sanction. That was only a guideline laid down by the Supreme Court in Swami's case. But now the prosecution is saying that they are ready with the sanction. Then now all the argument of deemed sanctions goes, your no sanction goes because they are producing sanction. So then what is your other argument? Should we wait for the sanction order? Or do you have any other argument on merit? Otherwise, we wait for the sanction.
They'll come in few days time. Request them to speed it up. Expedite.
Or you can say that even if there is a sanction, for argument's sake, let us presume that there is a sanction. Still, on the merit of the case, no case is made out under the PCI. Then now you have to argue on the merit. Yes. Your entire argument goes off on the sanction. You say that there is no sanction, they said we will produce sanction. They argued that no, even if you don't produce the sanction, there should be deemed sanction. So you produce a judgment saying that Swami's judgment does not say that deemed sanction can be considered. So we go by you, that we will not, presume that sanction has been granted by resorting to deemed clause. So what is your argument now? Yes, what is your argument? Anything? On merit you want to argue or will frame charge? You want to argue on merit? That charge cannot be framed? Sorry? So we'll wait for a sanction order.
Yes, can do that.
And once you get the sanction order, if you want to argue on merit, we'll give you a chance to argue on merit. And now that argument of sanction will not stand.
Yes.
All right. Now this judgment also doesn't help you. This is during the trial when an accused is added. Even an accused who is added during the course of trial, if he is a public servant or discharging public duty, sanction under section 19 is necessary for a person to be prosecuted at any stage in whatever manner if you are prosecuting him. If he's in the charge, if been charge sheeted against him, sanctions required. If he's made an accused during the course of trial by invoking section 319, still sanction is required. The judgment says so. That this is nobody's case that the accused has been added at the time of framing charge. We have not added them, but they are accused in the charge sheet. Learned counsel, learned prosecutor. Shri so present. The accused, who are the three accused persons? Nini?
Yes, sure.
Lari Parbang.
All three accused persons
Dua
present
Siti
along with
Kumon
the
and,
learned defense
Nini
counsel.
Wanda.
All right. Learned prosecutor submits that he has instruction that the sanction, a prosecution sanction under section 19 of the PC Act has been accorded, and it shall be placed before this court in due course of time. The defense counsel prays for time, or the prosecutor prays for time. The defense counsel has extensively argued that in absence of prosecution sanction under section 19 of the PC Act, the accused persons cannot be prosecuted. He has placed reliance on a decision of Honorable Supreme Court in Sunita Totija versus State of UP, AIR 2025, SC 1308. Relevant paragraph is paragraph 31 and 32. The learned defense counsel, relying on the aforesaid paragraph of Sunita TOTE, Suni SUNEETI, Suniti, sorry. Learned defense counsel, relying on the aforesaid paragraphs of Suniti Totija Supra are submitted. The sanction cannot be deemed to be accorded if if the sanction is pending for consideration. The law laid down in Dr. Subramaniam Swamy, this one. Law laid down in Dr. Subramaniam Swamy versus Dr. Manmohan Singh, 2012, SC, AIR 2012, SC 1185 does not lay down the law for deeming sanction. For deemed sanction, sorry. It only lays down the guideline which has not been translated into law, by the legislature. This court finds a force in the submission made by the defense counsel, which is supported by law. However, in view of the submission made by the prosecutor, learned prosecutor, that the sanction for prosecuting the accused persons shall be placed before this court in due course of time. The entire argument of the defense is rendered infructuous. Our prosecution is at liberty to place the sanction order before this court. If they don't place, we will look at this judgment and will decide. Okay, we agree with that. Your this judgment. We cannot draw the deem clause.
Counsel for accused number 2 was absent, Your Honor.
Who number 2?
Duarte.
Who is appearing? Yes. What do you want to say? Yes.
He wants to say something.
Yes, come there. Give me this judgment, put it properly, just and require it. Yes.
Your Honor, actually, I've tried to handle the case seriously from the beginning, and till date. But the matter is that since till date, I was able to acquire a legal counsel counsel. But Your Honor, now that I've reached a point of very serious financial constraint, you know, so Your Honor, I am the sole earner in a family. I have 2 children, and then also 3 brothers to look after. So Your Honor, and that is after my mother passed away in 2017. So right now, Your Honor, being working as a contractual teacher, so I'm in a very difficult situation right now. So right now I'm no longer able to afford the private counsel, Your Honor. So I beg your your mercy for granting me legal aid if appropriate, Your Honor. This is to add, Your Honor, this is also the reason for me missing the last hearing, which is on 26, 27, but it was shifted. The date was shifted to 27, and I rely on the online portal for the date. So that is why, Your Honor. So I seek your request to get a legal.
Where are you teaching?
Teaching in a contractual.
Where?
Silamantang.
Where is this place?
In Raskin block.
How much you paid?
Near Borto.
How much you paid?
Yes, Honor.
How much salary you get?
30,000.
So you cannot afford lawyer.
I've tried even from the beginning, but till now, then I find it that as the case proceed, then I feel like it's very hard for me because I'm the only person working, and I have to take care of around 6 people in a family. So that is why, Honor. If you just appropriate report, then I seek for legal aid if possible.
You want 3,60,000 in a year. You want 3,60,000 in a year.
Yes.
You move bail.
Sir, Baba.
Then
He was actually he got transferred to Nongstoin, and then my case was taken by Counsel Hing. So right now actually my last counsel is Hing. So but now I cannot proceed here with him due to this matter, financial matter.
who suggested you to pray for a legal aid counsel?
Nobody, Your Honor, the circumstances like.
How do you know about legal aid?
I go through that. I go through the online portal. No,
Mm-hmm.
I go through the online.
Then you apply online.
Just I go through just to know.
You apply. You will not pass in your. You apply online.
But I want to seek it from you, Your Honor.
Sorry?
I want to seek the.
You apply. You can apply legal aid counsel online in the national NALSA portal. You'll go to Delhi. From Delhi, it will come here. You apply online. Ask this. Call this John. We have online portal here.
I'm from the online from the online website that within the district. From there, I learn about legal aid, legal aid, Your Honor. That's what I mean. I learn about the legal aid from the online.
We'll give you full legal aid. You want full legal aid?
I don't understand.
You will get everything free. You want that? We'll give you everything free. Food also will give you free. You want? We'll give you free food, free vehicle, free medicine. Do you want that? We'll give you everything free. You remain in jail. You'll get free food, free vehicle, free doctor, free medicine. You want that? When you fall sick, do you go for free medicine or you buy medicine?
Buy. To buy.
When you have legal problem, why do you want free?
I'll try to
It's up to you. You want, we'll give you a package, free package. Free food, free vehicle, free medicines, everything, nothing. You don't have to work also. Whatever work you'll do in jail, when you are released, you'll get the money for that. We have a portal for legal aid, district portal.
Yes, sir.
In the district.
Yes, sir.
They can apply online.
They can apply.
Online. You apply online. You apply online. They will consider the DLSA. All right. What is the but we have kept the ceiling 3 lakhs. But you are a tribal, you'll be entitled to legal aid no matter whatever income you have, is your income. Otherwise, we have keep a slab of 3 lakhs. But your income is more than 3 lakhs, 3,60,000. In the online portal, they can apply.
They can apply that. Then we will review and then we will see whether he is eligible or not.
Okay. You apply online. In the portal, are you sure? Yes.
Yes, sir. Legal service management system.
Okay. Okay. But if you want from us, we'll give you free legal aid for everything. Free food, free medicine, free place to stay, no rent, nothing. And whatever work you have done, the work for, and once you are released, you'll get money also for that. You want that? We'll pass an order. Yes. Present accused Nini, who is the accused? You are Larry Cooper. You are Larry Cooper. Accused Dwarki T. Bamon. Present. The accused has expressed his financial disability to engage a counsel for the purpose of to engage a defense counsel. The accused by profession is a teacher. His annual income, as stated by him, is 3,60,000. Full stop. The accused by profession is a teacher. A legal aid cannot be provided merely on asking. The person has to be eligible for a legal aid counsel. Full stop. The accused informed that he is literate. He is a computer literate and has access to the portal of legal aid, portal of DLSA, Joy. The accused is at liberty to apply for legal aid through online. And the accused is at liberty to apply online legal aid in the portal, which shall be considered in accordance with law. As stated above, this matter will come up. As stated above, this matter will come up for consideration of charge. The prosecution is at liberty to place the prosecution sanction under section 19 of the PC Act before this court. How much time you require?
I'll have to talk to the authorities.
Tell them by next date, if it's not produced, then we are taking in consideration the judgment placed by him.
Talk with the
yes, we will discharge them. Okay. Okay. Yes, yes, yes. You apply online?
Up to son.
Yes. Yes.
Son.
Yes. Table C. I add just point number 3, no? Point 4, determination number 3. Page 19. Whether the accused A1, A2, A3 had burned the house of the PW1, PW2, and destroyed, burned and damaged the house of PW1, PW2, and damaged the ginger plantation of PW1. Let's read that point number 1.
Whether PW2, PW1, PW2, PW3 was summoned by the accused A1, A2, and A3 in the doorbell of Bamkamar village on 27/3/2025, White Exhibit 1, and in the meeting they were excommunicated. On perusal of the evidence of PW1, this court finds that PW1 has categorically stated in her evidence that she received a letter on 26/3/2015 asking her to appear in the doorbell of the village on 27/3/2015. The letter has been exhibited as Exhibit 1. There was no objection raised by the defense when the letter was exhibited. It was an original copy of the letter. The letter was written.
It is.
The letter was written in a vernacular language. It reads as here under. To bring Nongrum. With regard, I am to inform you that I got complaint from Josephine Nongrum, Monica Mokim, and Rebecca Mokim. Therefore, kindly come and be present on 27/3/2015 at 6 a.m. With this, you have to understand. The argument of the defense that an expert witness has to be established that the letter was written.
The argument of the defense that an expert witness
has to be established.
The expert witness has to establish, not has to establish. An expert witness has to establish. All right, the expert. The argument of the defense that an expert witness has to establish. Yes, okay. Has to establish that the letter
was written by the accused A1.
That letter is exhibit.
This is
who's appearing for the
exhibit
prosecution?
Exhibit 1.
Exhibit 1.
Then you write down exhibit 1. The letter exhibit 1 was written by accused A1. Appears to be misplaced. Then
the question of the expert opinion would arise when there is a serious dispute with regard to the person who written the letter. No such dispute was raised. No challenge was made in the cross-examination. The evidence of PW2, PW3, PW4 corroborates with the evidence of PW1 that summons was issued by the accused A1 to PW1 to appear in the Dorbar. The accused, in his statement under 313, has explained under what circumstances he had summoned PW1 to the Dorbar. What happened in the meeting held on June 23, 2015? The witness PW1 has stated in her evidence that she went to the Dorbar along with her siblings at 7 a.m. in the morning. The accused A1, A2, and A3, along with the villagers, were present in the Dorbar. They accused PW1 of practicing witchcraft. PW1 tried to clarify. No attention was given to her clarification. The three accused persons, along with the villagers.
The PW1 tried to clarify. Yeah, okay. Clarify, comma.
No attention was given to her clarification. The three accused persons, along with the villagers, PW1 along with her family to leave the village with dire consequences. This evidence of PW1 has not been disturbed in this examination. It corroborates with the evidence of PW2, PW3, and PW4. The IO, during investigation, found that there was an allegation of practicing witchcraft against PW1 and her family, and it was the genesis of the trouble. This court finds no good reason to disbelieve the evidence of PW1, PW2, and PW3 that they were summoned by accused A1 in the Dorbar of Bangkomar village, and in the meeting, PW1 and her family was alleged of practicing witchcraft. Further, in the meeting, it was decided to excommunicate PW1 and her family.
Yes, next point.
Whether the accused A1, A2, and A3 had issued a warning note to PW1 threatening her not to visit the village with the consequences that they would burn the house and damage the ginger plantation. The evidence of PW1 reveals that she attended the meeting on 27/3/2015 in the village Dorbar of Bangomar. In the said meeting, she was excommunicated. After she was excommunicated, within a very short time, she left the village and started staying in the neighboring village known as Umupia along with her relatives. PW2 also left the village after being excommunicated. She went to stay at Longka village as she had a house there. PW3 also left the village and went to stay at Umupia village. PW3 has explained in her evidence as to why PW2 went to stay at Longkia village. PW3 has stated that PW2 had a house at Longkia village. That's why she went to stay at Longkia village. The evidence of PW2, PW1, PW2, and PW3 is on the same page and is consistent that later in the month of August, they received a warning note from the headman A1, and the warning note was addressed to PW1, threatening her not to visit the village or the cultivation field. Any defiance to the warning will be meted with the consequences of burning the house and destroying the crops.
Method. METT.
This court finds no good reason to disbelieve the evidence of PW1, which is consistent and corroborates with the evidence of PW1 and PW3. It gives further fortifies with the Exhibit 2 destroying the crops. It is reiterated.
Fortifies with Exhibit 2. What is that Exhibit 2?
Exhibit 2 is the letter of the threatening letter on the second letter.
Consistent and corroborates with the evidence of PW1 and 3. It further gets fortified with Exhibit 2. Where it further gets fortified by Exhibit 2, where PW1 was threatened that her house would be burned and crop be destroyed. Yes. Then
it is reiterated that Exhibit 2 was exhibited without any objection. There has been no challenge to Exhibit 2. The Exhibit 2 was written in a vernacular language, Khasi. Exhibit 2 reads as here under. To Brin Nongrum. With this, we as the Bangkomar village, we again inform you from 26/8/2015, you are not allowed to set foot on Bangkomar village. If we find anyone from your family, they will be punished according to the law of our village. You must permanently leave the farming, which is under our area. You should leave the ginger, which is under your cultivation. You cultivating ginger without getting permission from the village. After you were chased, the village has decided not to allow you to farm, but still you are farming. So the village now is strict against you. If you don't agree, we will burn down your house. Only this, I believe you understand. In absence of any challenge to Exhibit 2 in cross-examination, it will be not necessary for this court to call for an expert to determine the author. Expert opinion will be necessary in cases where there is a serious dispute as to who had written Exhibit 2. The evidence of PW1 reveals that she had a ginger plantation and a house at Bangomar village along with her family, PW2 and PW3. They were excommunicated on an allegation of practicing witchcraft. They were asked to leave the village with a threat or consequences. PW1, PW2, PW3, and PW4 left the village out of fear and threat. Their house and ginger plantation was there in Bangkomar village. It is natural that they would like to see their belongings and the ginger plantation. Even after being excommunicated, they would visit and work in the ginger plantation field. Exhibit 2 reveals that it was not taken well by the villagers at Bangkomar that after PW1, PW2, and PW3 was excommunicated, they were still visiting the village. As such, Exhibit 2 was issued by A1. On plain reading of Exhibit 2, it is very cruel. It was not only
Very clear.
On plain reading of Exhibit 2, it is very clear. It was not only on simply warning, but also a direct threat of destruction of the property. It is connected with Exhibit 1. There is a mention in Exhibit 2 with regard to PW1 being excommunicated. This court finds that Exhibit 2 and Exhibit 3 was found from the possession of PW4, who is none other than son-in-law of PW1. If Exhibit 1 and Exhibit 2 was not served on PW1 or her family, how they have come in possession of Exhibit 1 and 2. There has been an argument on the genuineness of
Your Honor, I would like to, in the cross-examination of the blue one, so it was stated by the blue one, Your Honor, that in paragraph 7, that the Exhibit 1 and Exhibit 2 was handed over to the police by the PW4, who was accompanied me to the police station.
Yes, we have said that. This court finds that Exhibit 2 and 3. Exhibit 2 and 3 or Exhibit 1 and 2. What is Exhibit 3?
Exhibit 2 are the letter. Exhibit
And
3
3
is
is
the
the
cease and
FIR.
desist.
Exhibit, this paragraph, this court finds that the Exhibit 1 and 2 was found
from the possession of PW4.
It was seized from the possession of PW4, who is none other than the son-in-law of PW1. Yes, 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 yes. At this point, we continue with that. Is unchallenged in cross-examination required to be independently established by an expert. At this point, this court would like to clarify. Once a document is exhibited, the document, the document comes in the docket. The document is brought on record. The court can look into it while arriving at a decision. A document being admitted during trial is one thing, and the content of the document being proved is another thing. The content of Exhibit 1, where is it Exhibit 1 and 2? The content of Exhibit 1 and the content of the Exhibit 1 and 2 has been established by Exhibit 1 and 2. The content of Exhibit 1 and 2 has been established by PW1 PW2 and PW3. Full stop. The prosecution has established where that thing. When was this PW this thing? PW this Exhibit 2 was issued when?
Exhibit 2 was issued on 26 August 15, Your Honor. Yes, dated 26 8 of 2015.
Come to page 21. No? Page 21 is whether the accused A1, A2, A3 had issued a warning notice, a warning note to PW1, Exhibit 2, threatening her not to visit the village with the consequences that they would burn the house and damage the plantation. Then do you see this? What do we see? Last sentence.
The content of Exhibit 1 and Exhibit 2 has been established by PW1 and PW2 and PW3. The prosecution has established.
Prosecution has established that the accused. Prosecution has established that. Where is it? Where is that Exhibit 2? Give me that classic copy. Who is the author?
Maham ya fi Krishna Mangamar.
What is it?
Kabroni Kalia.
prosecution has established
that Exhibit 2 was issued. Exhibit 2 was served on the PW1, to whom it is addressed.
PW1, yeah.
Was Exhibit 2 was served to PW1. The content of Exhibit 2 clearly established the content of the Exhibit 2, which has been established by PW1, 2, 3, clearly manifest that PW1, along with her family, were asked to leave the village with the threat permanently with the threat of destroying the farm, the ginger plantation, and burning the house. The content of Exhibit 2 constitutes a criminal intimidation. A criminal intimidation has been defined under Section 503 of Indian Penal Code. For easy reference, Section 503 is reproduced. The act of the accused reproduce, full stop. The accused persons were all present in a meeting of Darbar held on, when was the first meeting held?
On 27.
held on 27
March 15, Your Honor.
15, where the accused person, where PW1 and her family was accused of witchcraft.
On that day, Your Honor, the accused person summoned the victim to the Darbar of the Darbar Snong Hall to resolve the matter. To resolve the matter.
Person, where the PW1 and her family was accused of witchcraft.
Not with the intention to ostracize them or to
and in the meeting,
they don't have the intention, the bad intention, Your Honor.
PW1 and her family was ostracized.
On 27, the accused summoned the victim
by the village Darbar of Bamkamar village. The village Darbar was headed by, who was the president of the Darbar? Who was the president of the Darbar?
Rimanus, at that point of time, Rimanus
the village Darbar was headed, who was the president of the Darbar? Secretary? Kaun tha secretary?
Gilbert.
And then who was the headman?
Rimanus Ksir.
And he, this one?
Secretary.
Who's secretary? Chairman. All right. The village Darbar was headed, who is the chairman? Name?
Edmund.
Headed by Edmund as chairman. Then Rimus Dakhar as a Ksir, as a headman. And this one?
Gilbert Nongrum,
Gilbert Nongrum as a secretary.
Secretary of the Darbar, Bamkamar.
Pusto.
On the basis of Exhibit 1, Your Honor,
there has been an argument by the defense counsel that the entire village was involved in the meeting.
Your kind permission, Your Honor.
One second. The entire village was involved in the meeting. The accused persons alone cannot be held liable. Gustav. The argument the argument appears to be the argument cannot be accepted. The argument of the defense counsel cannot be accepted, inasmuch as the decision, inasmuch as the village Darbar was represented by the three accused by the accused persons, and they had issued Exhibit 1 and Exhibit 2. The first letter was the decision to excommunicate. The Exhibit 1 was the decision to excommunicate.
The Exhibit 1 is the notice issued by the headman of the Darbar Snong Bamkamar to the victim
the Exhibit 1
on the basis of complaint given by these three ladies.
Exhibit 1, the first letter, Exhibit 1.
They don't have the bad intention to excommunicate or ostracize.
The first letter, Exhibit 1, was the notice for appearance. And what transpired in the meeting? Exhibit 1, first letter, Exhibit 1, was a notice for appearance of PW1 in the village Darbar.
Because this
what transpired in the meeting held on 27? Meeting we held on
27
is elucidated in Exhibit 2. Stop. The prosecution has established that the accused persons have committed an offence of criminal intimidation, which is punishable under section 506 of Indian Penal Code. Next point.
Whether the accused A1, A2, and A3 have burned and damaged the house of PW1, PW2, and destroyed the ginger plantation of PW1.
Stop. This is a case of a mob violence. This is a case of a mob violence under the backdrop of the allegation of a witchcraft. The informant PW1, where is this FIR? The informant PW1 who had filed the FIR, which has been exhibited as Exhibit 3.
Exhibit 3.
As alleged in the FIR, that she was summoned by PW1. He was summoned by accused. What's the name? The headman?
Riminus Xier.
By Exhibit 1 to appear in the Darbar on 27/3/2015.
Your Honor, with due respect.
And in the meeting held on 27/3/2015, PW1 along with her family were threatened to leave the village within 1 week. The facts stated in the FIR corroborates with the evidence of PW1, PW2, and PW3. In fact, PW In fact, PW2 and 3 are also signatory to the FIR Exhibit 3. This court has already discussed above that Exhibit 3, Exhibit 2, issued by the Darbar of Bamkamar village, establishes that PW1 and her family were threatened to leave the village, were threatened of their property, threatened of their destruction of their property and life if they did not leave the village. If they did not, if they did not leave the village permanently, abandoning their house and ginger cultivation. Full stop. After receiving PW2, after receiving Exhibit 3, PW1 along with her siblings. The PW1 along with PW2, PW3 approached the Natiang police station and filed the FIR. Rated. What is the date of FIR?
Date of FIR no.
First September 2015 on 1st September 2015.
Exhibit 3. Which is the IO? PW7 IO. After receiving the FIR.
With this, Your Honor, you see, Sri weekend field shooting, W shooting,
PW4. PW7 after receiving the FIR. Went to the PO. And found the house of PW1 was lying abandoned as the house as PW1 had left the house on 4/4/2015. The house was damaged by unknown person. PW7 also found the house of PW3 was damaged. Even the house of PW2 was damaged, and some portion of the house was burned. The ginger plantation near the house of PW1, 2, 3 was damaged. During investigation, PW7 found that the villagers of Bamkamar village had damaged the house of PW1, 2, and 3 as they believed PW1, 2, and 3 were practicing witchcraft, and the villagers were falling sick. The village authorities had expelled PW1, 2, and 3 on 27/3/2015. The IO had made a seizure. What has been seized through Exhibit 4?
Exhibit 4, Your Honor.
Proceeding register.
Exhibit 5?
These two copies of original letter.
The IO had made a seizure by Exhibit 5. The letter issued by the village of Bamkamar, which has been exhibited as Exhibit 1 and 2. The IO has exhibited the photographs of the damaged house of the PW1 and 2. The evidence of the IO with regard to the damage of the house, seizure of exhibit 1 and 2, has not been disturbed in cross-examination. However, the IO PW7 has stated that during investigation, he could not trace the person involved in damaging and burning the house of PW1, 2, and 3. The IO could not ascertain that could not ascertain the perpetrator who had caused damage to the ginger cultivation of PW1, 2, and 3. The genesis of the instant case is on the allegation of witchcraft. The whole village was mobilized against PW1 and PW2, PW1, PW2, and PW3. The evidence on record discussed above reveals that the PW1, PW2, and PW3 were asked to leave the village under threat, and the threat was translated into reality by the residents of the Bamkamar village. This is not a case where the accused persons have been charged to have assembled with a common intention, common object, bracket section 149 IPC. Further, the prosecution has failed to establish that the accused persons had instigated the villagers to burn the house of, to damage the house of PW1 and 2, and further to cause damage to the ginger cultivation. In absence of the any cogent evidence to manifest that the Darbar meeting which was held on 20, when was the Darbar meeting held?
27 March 2015, Your Honor.
Was an assembly of the village members, was an unlawful assembly of the village members with an object to destroy, damage and burn the house of PW 1, 2 and 3, or to cause damage to the ginger cultivation, this court find it is extremely difficult. And this court finds not difficult. This court finds there is no evidence to show the accused persons has either caused damage to the house of PW 1, 2 and 3, or has instigated the village members of Bamkamar village to carry out any unlawful act. There is also no evidence on record unfolded during trial to establish that the accused had caused any mischief in the nature, cause any mischief leading to damage in the absence of the evidence to establish that the accused persons had burned the house of PW 1 and 2, and further, in absence of any evidence to show that the accused persons had burned the house of PW 1, 2 and 3, or caused any mischief the accused persons are acquitted of the charge under section 435 and 327. For the reason, next paragraph, conclusion. For the reason discussed above, this court finds the three accused persons guilty for an offence under section 506 IPC and for the offence guilty. For the reason discussed above, the accused persons are acquitted of the charge under section 435, 327. However, 327, full stop. The accused give the name of three are found guilty for an offence under section 506 IPC. The accused persons who are on bail in the instant case are taken into custody. Yes. Anything you want to hear in sentence?
Yeah, we'll hear today only, Your Honor.
Tell us. Today is very late now. We want to hear. What is the sentence 506? They tell them these three, they are found guilty.
Era siya mo pila ta wala ni kamu ni kandan wa penting pinara ni brinda no room.
There are two parts here. First part is which may extend to 2 years. And the next part is if threat be to cause death or grievous hurts, etc. And if the threat be to cause death or grievous hurt or to cause the destruction of any property by fire or to cause an offense punishable with death or imprisonment for life or with imprisonment for a term which may extend to 7 years.
Oh. Okay.
Or to impute unchastity to a woman.
Yes, yes.
Shall be punished with either destruction. Should be extended to 7 years.
Yes. Yes. How many years you want?
Here I will go with this part 2.
Oh.
And it clearly stated I will pray for 5 years.
5 years?
Yes. Because it,
okay, 5 years will put.
No, Your Honor, I would like to object to the submission raised by the Internet prosecution. Because on record, Your Honor, on the first day, on 27, as per the Exhibit 1. Exhibit 1
No,
is...
no, we are on sentence. We have already convicted.
I will come to that. I mean, that definition of the 506. First category and second category, Your Honor. Because from the start of the case, the three accused
Okay, why
persons
don't you take the judgment, copy of the judgment, and we'll hear it on Monday? We'll hear on Monday.
Yes.
You come prepared for hearing on sentence. Tuesday we'll hear. Monday I might not be there. Okay. Oh, you were prepared for hearing, then we can hear.
We will hear.
You want 5 years?
Yes.
5 years jail?
It is.
We'll hear that quantum of sentence will hear, sir. Because right now, still the court not yet there. Give us a time, chance to argue regarding the sentence, Your Honor. Because clearly we have seen that the accused person here is only scapegoat. They don't have any intention to ostracize or to threat the victim. Because on the first day, they were called the victim to resolve the matter. But unfortunately, due to the pressure from the public, so they could not solve the matter. And that's only the reason of this case. Your Honor. After all, they don't have any malified intention to. That notice also received by the Rangba Chnong on the basis of verbally information by the three ladies. So being the head of the Darbar Chnong, their duty bound to call the the victim to discuss the matters, not to give any threat to the victim or to ostracize her. But it is only because they could not control the public under pressure, then this case arose. So they don't have any bad intention, such a bad intention to threat or to ostracize the victim. Your Honor. So on that basis, I pray the court give us a chance to argue with regard to section 5.
But he's fair. He's asking 5 months, 5 years enough. That's fair enough. Why waste time? For 5 years, how many days they spend in jail?
90 days.
Kalau sini sakit ni, Subhasni boleh benar. 40 days. Your Honor.
You say 90 days.
Appreciation.
Will Your Honor allow us to do the hearing regarding the quantum of sentence? Because
Why wait till Monday, Tuesday?
Yes, sir.
506 matter. Will this suppose so? 5 years is good enough. Enough, fair enough. Or you
2
want?
years, Your Honor.
Huh?
2 years, Your Honor, because this is a mob. This is a mob. Actually, they are only because they are the executive member of the Darbar Snow, the exact culprit of the case who involved. In fact, they not established by the prosecution. So it is only because they are the chairman, the headman, and the secretary. So the complainant directly file put their name in the FIR. As a matter of fact, in reality, it's not them who involved in the case. Just because they could not control the situation on 27 March 2015 under pressure. So that's only honor. In reality, they are not the one honor. Because we have seen, even in their 131 statement also clearly they have stated we summon the Brindanong PW1, PW2, and PW3 along with her family on that set day to resolve the matter and to discuss of the allegation they have received from those three ladies.
We have to punish this witchcraft business. Slowly, it has
That
to
is
stop.
day by day, Your Honor, until and unless the law.
No, we have new act. We have witchcraft. We have in BNSS. We have.
Because this is common in the Hesi and Jaintia practice. This is very
It has to
common.
stop.
So, like this type of cases, then the
Accused this one pass order. Accused persons are present. Accused persons so and so are present. Judgment delivered in open court. Accused persons found guilty for an offence under section 506 IPC and acquitted of the charge under section 435 and 427 IPC. All right. The bail bond of the accused persons stands cancelled. The accused persons are taken in custody. Fixed for hearing on sentence. When?
tomorrow also, sir, why waste of time, Your Honor?
Tomorrow I'm not there.
Monday, Your Honor.
Tuesday or Saturday.
Tuesday. He'll be there Tuesday.
All right, Your Honor.
Tuesday.
All right, Your Honor.
Fix for fix this matter for hearing on sentence as prayed by the council, by the Rabble Council. On Tuesday is what day?
Into that.
24.
Please explain them. They have been found guilty for this.
24, Your Honor.
Yes, anything you want to say, these people? They are found guilty.
Ko December wato wa maham mo penting ya ni bru thang ni yung sem nam ka. Te da the system booking kat kamu ni ga kendon samspa andro. Ni agak ni kita maham pa. Ni ya le.
Tell them we'll hear on how many days on sentence Tuesday. We'll decide.
Aga singo a poyau em biang em kelam biang pa itema.
Right now we are sending them to jail.
Kata pa bisa jail.
If you say that his offense is under part 1, then I can allow them to go.
Yes, because.
But he's saying part 2. If it's part 1, then punishment is maximum 2 years. Then I can allow them to go. I can suspend the
No,
sentence.
Your Honor, this is part 1, Your Honor. Part
It's up
2
to
is not
you.
attracted.
If you
Your
can
Honor.
satisfy me that part 2 is not attracted, then I will not take the custody.
Part 2 is not attracted, Your Honor. As per the record and the scenario of the case also is not attracted, Your Honor, because their role is only someone the victim on 27. Prior to 27, also they don't have any knowledge about the witchcraft practices by the victim, because the notice as per Exhibit 1 was issued to her. It is only based on the information given by the 3 ladies. Oh, this Brindanong room, this one or one, because these 3 ladies, they are neighbors with the,
Yes.
So why?
Let's not go on the facts, let's go on the law. If it is part 1, then I will not allow, because the punishment is up to 7 years. I will not allow them to go. But if it's in the part 1, I'll allow them to go. I can in fact decide right now if it's part 1. But if it's part 2, then I should give them chance.
Because, Your Honor, if it is established, the
destruction
damage.
of property also present. A threat to cause grievous hurt or some.
There is no grievous hurt, and the damage not established by the prosecution, Your Honor.
Involved here.
Damage of the ginger plantation not established by the
These
prosecution.
people, they are staying in the village?
Yes, Your Honor.
The PW 1, 2, 3?
Yes, Your Honor.
They are still the headmen?
No, Your Honor, not the headman. Only that point of time. Now he is a common man, not a headman.
Anybody running the village?
They are only the member of the Darbar Sinong, but not holding any post like secretary, chairman. They are only the executive member of the Darbar Sinong. So that is why, Your Honor, part 2 of 506 is not attracted. And the IO also, after the FIR lodge, 3 days, he went to visit the PO. And as per the statement of the Dores Sariang, the PW4 also, he said that I did not know who burned our house. So that is why, Your Honor, part 2 of 506 is not attracted.
No, we have not convicted you for burning the house. We have acquitted you. Section 435, we have acquitted you.
Yes, Your Honor.
But threatening to yes, you call in the meeting and threaten them.
So in the meeting also, Your Honor, actually they are not the one.
Exhibit 2.
It's not the one. After the, Your Honor, after the meeting over on that day, since the matter was not resolved, some of the public from the village, even they came to the house of the Rangba Sinong and threatened him. Why don't you do this? Why don't you do that? He don't have the intention to do such a thing. It was an accident on that day. No motivation, no preparation.
Okay, I understand.
No motive, no mens rea, Your Honor.
But will it go under part 1 or part 2? If you can satisfy under part, if you can satisfy me that it will go under part 1, and then we dispose of right now.
Because, Your Honor, sometime the 506, it says that a mere expression of any words without any intention to cause alarm would not sufficient to bring an application of Section 503.
But
So,
here theft is there.
on that day, Your Honor, they didn't.
They issued a letter.
In fact, that letter also, Your Honor, the letter as per Exhibit 2 was issued on August.
Huh?
On August, 26 August. 26, that's that threatening letter, Exhibit 2.
And when was the house
Incident was, I mean, the first meeting was called on 27 March. And 6 months after the incident, then that threatening letter, that also it was a doubtful document, Your Honor. Issuing without any seal, without any, that also, Your Honor, it's not to be accepted in reality, Your Honor. Facts and law, it's not accepted.
All right, yes, yes.
So how that part 2 of Section 506 attracted is not attracted, Your Honor. And even in the 313 also clearly, we call the victim on the 27 on the basis to discuss the issue and to resolve the matter. As per the allegation made by those three ladies, the neighbors of the victim have allegation to the victim that they practicing a witchcraft. Their relative fall sick because of the tarot, what they call that devil spirit, as allegation to the victim, Your Honor. That's only, Your Honor. They don't have any mention or bad intention. So accidentally on that 27, due to the pressure of the
one sentence.
public,
Counsel, her learned prosecutor, Sri so and so. Her learned defense counsel, Sri so and so. The three accused persons, in the name, has been found guilty for an offence under Section 506 IPC.
156.
And were acquitted of the charge under Section 427, 427, no? 427,
427.
and 435 IPC by judgment and order dated
Because the law very clear. The law very clear, say, Your Honor. A mere threat.
One second. By judgment order dated today's date, 19 this matter is being heard before sentence. The prosecutor submits that the case would fall under Part 2 of Section 506. Where the punishment can extend up to 7 years or with fine or with both. The learned prosecutor further submits that the accused were involved in threatening an innocent villager to leave the village. Further, the accused person had excommunicated the family of PW1, destroyed their crops. As such, the prosecutor prays for severe punishment in order to deter such actions, criminal actions. Another prosecutor prays that the accused may be sentenced to 5 years of rigorous imprisonment with fine. Stop. A learned prosecutor, a learned defense counsel, in response, submits that the accused person has been made a scapegoat in the instant case. The entire village had turned against PW1 and her family, as they suspected PW1 was involved in the practice of witchcraft, and people were falling sick in the village.
Not in the village, Honor. Only to, not in the village, only to the neighbors of the victim.
All right, that is in the
PW1,
village.
yes, in the village.
In the village. Full stop. Learned defense counsel further submits that the convict were the head of the village darbar, at that point of time. And they tried their best to pacify the villagers and stop the villagers from resorting to any unlawful act. The defense counsel also submitted that in this part of the village, in this part of the district, the superstitious belief of witchcraft is predominant. Due to ignorance and illiteracy. No doubt, the house of PW1, 2, and 3 was damaged, but the accused persons did not have any role. On contrary, they tried to control the villagers. Further, the accused persons had called for a meeting to resolve the matter, but the villagers were adamant on their superstitious belief. And they wanted PW1, 2, and 3 to leave the village. And some unscrupulous villagers took advantage of the situation and caused damage to the house of PW1, 2, and 3. Stop. The defense counsel submits that it is not a case where the accused persons had led the mob to cause the damage of PW1, 2, and 3. The accused persons have been nailed in the instant case solely on the ground that they were the local heads of the village at that point of time. Stop.
Because I would like to add, Your Honor, because there is one ruling in Manik Tanija versus State of Karnataka, 2015, 7 SCC, Your Honor, this appellate court had observed that simply abusing or threatening language without any intent to cause alarm does not come within the scope of Section 503 IPC.
But here you have burned the house.
No, Your Honor, I'm not.
Forget about alarm. You have acted upon your threat.
Yes.
It is not a case that we are simply examining the threat. The threat has been translated into reality by burning down the house.
That is what, Your Honor, we are only discussing. We are not involved in burning the house of the victim, Your Honor.
That upon hearing the rival counsel, this court finds at the very outset that superstitious belief is a belief without reasoning, and it needs to be abhorred. This court understands that primitive thoughts, primitive ideas and thoughts which are colored with ignorance gives rise to unreasonable belief and poses serious threat to life and property of people. Stop. This is a case which is no different to ignorance and this is a case which is no difference to the consequences of this is a case which depicts the consequences of the superstitious belief of a witchcraft. So, this court understands and this court is privy. Don't privy, PRIVY. This court is privy to the fact that in rural area
not only in rural areas, sir. The whole this
court is privy to the fact that particularly in the rural area where there is no education, superstitious belief thrives, and it is exploited by some unscrupulous people. This court finds that the evidence which is unrolled during trial clearly demonstrates that a complaint was made before the local heads headed by the accused persons, accusing PW 1, 2 and 3 of being involved in the practice of witchcraft. The accused persons did not act upon the complaint. Rather, they had called for a meeting. When was the meeting?
27
On 27 March 2015. The matter was discussed in the meeting. Perhaps the villagers insisted the accused to leave the village and abandon their cultivation. The victims left the village. However, they would frequently visit their house and field in Bamkumar village. Which antagonized the villagers. Consequently, the property of PW1, 2, and 3 was damaged. Exhibit 2 is a letter issued by the village authority. No doubt, the tenor of the letter is in the nature of threat, which constitutes criminal intimidation. One cannot lose sight of the fact that the accused persons come from rural area. They are not conversant with sophisticated way of writing and conveying their thoughts and conveying the message. This court finds that this is not a case where the act of the accused would fall under Part 2 of Section 506 IPC as argued by the prosecution. The case of the accused will squarely fall under Part 1 of Section 506 IPC. The maximum punishment for the offence can extend up to 2 years with fine. Is it with fine?
Yes, Your Honor. Which may extend to 2 years or with fine or with both.
This court finds that the accused persons do not have any criminal antecedent. They were the local heads of a remote village where superstitious belief of witchcraft incited the villagers to cause damage to the property of the victim of PW1, 2, and 3. The accused had faced trial for how many?
Since 2015. Yeah.
Charge frame when?
Charge frame on 16 August 2017.
The accused has faced trial for almost 10 years. Court is not inclined to Snake, this court is of the view. The accused person. How many days he was in jail?
40 days.
40 days, Your Honor.
Simple imprisonment of 40 days. Full stop. The accused persons had suffered the sentence period during detention. So, the period undergone under detention is set off. The accused persons had served the sentence. This court finds further deems appropriate. This simple imprisonment of 40 days with fine of rupees 5,000 each. Failing which the accused persons shall suffer the sentence of 10 days of simple imprisonment. You pay a fine, otherwise we put you for 10 days. Okay. Case stands disposed of. They can go. They have served the sentence. 40 days, are you sure?
Yes, Your Honor.
Yes.
Check it.
Yes, we will check.
Okay. Case stands disposed of.